In a medical malpractice case in New York, can the medical expert who comes in to support your case come in and ask for a contingency fee in order to get paid? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. The answer is no, he can't. A contingency fee means that the doctor only gets paid if we win our case. Now, if the doctor were to do that, that would mean he would have a vested interest in seeing that you win your case. That the doctor would now do everything possible and say anything, virtually anything, in order to get you to win your case. Because the doctor would know that if you lose your case, he gets paid nothing. So now it would be so easy for the defense attorney to turn around and destroy this doctor's credibility at the time of trial. So let me give you an example. Imagine the doctor's on the witness stand and now the defense attorney has an opportunity to question the doctor and cross-examine him. Dr. Jones, you're being paid for your time here today, isn't that true? Well, I'm not being paid for the time here. I'm being paid for the time out of my office, away from my patients, to come into court. Okay, doctor, in any event, you are still being paid. Mr. Oginski is going to give you money for coming into court and now explaining to the jury your opinions. Isn't that true? Yes. And doctor, how much are you being paid today? Well, I don't know. What do you mean you don't know? Aren't you being paid an hourly rate? No, I'm not. What arrangements do you have with Mr. Oginski? Oh, I'm being paid a contingency fee. Really, what is that fee? I'm going to get 10% of whatever the client wins in this case. Really? So now he's going to show to the jury that the doctor has a vested interest in winning this case. And at closing arguments, the defense attorney is going to turn to the jury and explain how this doctor is virtually going to say anything in order to get this case won. Why? Because if the injured victim loses the case, the doctor gets paid absolutely nothing. So now the defense attorney is going to show to the jury that the doctor has a clear vested interest and now he is biased. And that will destroy the doctor's credibility. Instead, the best and only practice is now if we pay the doctor an hourly fee for reviewing the records, an hourly fee for discussing the case with me, and an hourly fee for coming into court away from his practice and away from his patients. This way, now there's no vested interest in whether we win or lose the case, and that issue about credibility is all gone. So why do I share this great information with you? I want you to recognize how important this is and just give you a little insight into what goes on in the trial process here in the state of New York in a medical malpractice case. You know, I realize you have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Jerry, G-E-R-R-Y, at oginski-law.com. That's it for today's quick video. I'm Jerry Oginski. Have a great day.